introduction. I am Lisa and I'm very happy to be here today. I am talking about intellectual property rights, as in IPRs and licensing. I hope you still have some energy left. So yes, I work at Corporate Attorneys and I'm specialized in these topics, among other things. And as I am currently on a parental leave, still for a few weeks before returning back to work at the end of January, it's been very nice to dive into these topics after a very long break. Alright, so let's see the agenda for the last session, I think. First we will cover IP rights, what they are, what types of IPR exist, and then I will focus on trademark and company name, as well as copyright, since I think those are the most relevant ones for you to know. And then I will also explain briefly how you can legally use copyrighted works made by other people in your business. Then I will go into licensing, what does it mean, what types of licenses there are, and why are licenses granted in the first place, and also some practicalities related to licensing. And then if we have the time, I will also explain other legal requirements, such as possible permits to start a business in this field, and also some data protection issues, which is probably everyone's favorite topic. All right, but yes, let's get into the first IPRs. So, what is IPR? They are results of creative efforts from the human intellect that cannot be materially measured. So they are intangible assets, meaning that they differ from traditional tangible assets, such as cars or books or whatever you can just hold in your hand. Because you can, like, several people can own or use IP at the same time, unlike a car or a book. And then IPR, as in intellectual property rights, they provide the protection to IP. They help exploit and control IP and are exclusionary by nature, meaning that the owner of an IP can prevent its use by others who don't have the consent to use the IP. So IP rights give their IP holders exclusive rights to make decisions concerning the IP. Alright. Then here is a list of the most common IPRs. This list doesn't include database protection, which is also considered as an IP right. It protects the content and the structure of a database. But let's concentrate on these 6 ones. So IPRs can be divided into copyright and industrial rights. So industrial rights include patents, designs, trademarks, and company names, which are registrable rights. Unlike copyright, in Finland you don't need to register your copyright in any way. And so in Finland, the Finnish Patent and Registration Office is the relevant authority if you want to register, for example, a trademark or a patent or a design or a company name, which are the industrial rights. But let's have a closer look of these 6 IPRs, and then I will explain a bit more about trademarks, company names, and copyrights. So, I think you all know what copyright means, but let's still have a closer look. So, copyright gives exclusive rights to creators of an original artwork. It can be literary, scientific, or whatever artistic work. And copyright safeguards the author's economic and moral rights. Then patents, they have exclusive right to make, use and sell inventions for a limited period. Patents are enforced for 20 years maximum in Finland. You have to renew them every year. And so to be patentable, the invention must first of all be new, meaning that you cannot patent some already known technology. Secondly, it must involve an inventive step. And lastly, the invention must be industrially applicable. So they must be technological in nature, and they must solve a technical problem. So I will not go into patents anymore because I don't think they are that relevant for you in this arts and wellness business concept.
Lisa, there is one question.
Yes?
I know we are not going to go into, but it's just a question I have always had. Can you patent a practice or a methodology? No.
No,
Okay.
patents don't protect any ideas or methods as such. Like, of course, you can patent a method if it's like related to an invention,
Okay.
but like ideas itself are not.
I see.
Yeah.
Thank you.
Or a theory alone, they cannot be patented. Yeah.
And the technique?
Sorry.
The technique?
Technique? Well, yes. All sorts of technical solutions can be patented, but they have to always. There are these requirements, like it has to be new, it has to have the inventive step, and they must solve a technical problem.
Mm.
Yeah. So, a design right gives an exclusive right to use a design. In order to acquire a design right, the design must be new and has individual character. And it only protects the appearance of a product. For example, the unique shape of a Coca-Cola bottle can be protected by a design right. Also, I don't know, Adidas sneakers, if they are individual enough, can be protected by a design right. So it's only the appearance, and nothing like the technical solutions involved in it can be protected by a design. And they are also protected for a limited period of time, 25 years maximum. And then trademarks, well, they are exclusive rights over distinctive signs such as names and logos, and they function as identifying and distinguishing a company's products from another company's products. I will soon explain more about trademarks because I think that is a topic that is interesting for you. So, and then we have trade secrets, which protect the valuable and confidential business information, such as technology, formulas, or marketing strategies. For example, I think the Coca-Cola recipe itself is a trade secret because if Coca-Cola company would have patented the formula, how to, or the recipe, then it becomes public, so everyone else can use the recipe to develop their own. So that's why some companies want to keep their important information as trade secrets if they don't want to have that information go public. And also because patents are only valid for a limited period of time, the 20 years is maximum.
Mm.
So trade secrets are like, they can be protected forever if the company wants to keep it as a secret. And then lastly we have company names, which gives an exclusive right to an individual and distinctive company name. So the company name functions as identifying the company or entrepreneur from other companies in the similar field, as in trademarks distinguish the products from other companies' products. You have a question, I think?
So is a trade secret just out of curiosity, something that they're not actually disclosing, or it's something that they're just hiding, basically? instance, a trade secret, the trade secret basically something like the requirement that they're not allowing it, because a patent is what you then basically expose to the public.
Yes.
But the trade secret is basically a patent that's undisclosed, basically.
Well, trade secrets are, well, first of all, I'll explain a bit more. In order to become legally protected as a trade secret, the information must fulfill certain requirements set in the Trade Secrets Act. So it has to, well, I don't remember correctly all the requirements, but yeah, you can think of it as a patent, but you don't apply for registration for it. You can just like keep it as your secret information. But however, if you want to, for example, if someone infringes the trade secret by, like, let's say an employee tells the trade secret to someone else, and you want to take it into court, then in order for you to protect the information as a trade secret legally, it has to fulfill the requirements set in the Trade Secrets Act. So, like, not everything can be legally a trade secret if you want to, like, defend yourself against infringers. Did I answer?
Yeah, but then also is the trade secret something that you cannot do in hindsight in some way? Like, gave you an example of an employee taking a company and saying, oh, I found a trade secret, or I found a secret method that the company's doing. Of course, there might be that agreement, the legal thing between the employer, but unless that company actually filed that trade secret before the employee can that then be regarded as
of course, like two parties can invent the same thing at the same time, even like if they don't know about each other. That's of course fine. But if you intentionally tell a legal trade secret to someone else, then it's a different thing. Sorry, I'm not sure if I answered
about the
your
time
question.
of what you're trying to focus on. I don't think it's that relevant to what you're focusing on.
Yeah, I will not go into trade
It's
secrets.
just
That-
curiosity.
Yeah, I think it's good for you to know that like the requirements set in law, that there are 3 requirements. So if you are interested in the topic, I can tell you where to find the Trade Secrets Act. But it's good to like separate from patent, even though you can protect like technology as a trade secret, but also as a patent. But the difference is that patent goes public, trade secret never does, until the owner of the trade secret wants to publish it, if they ever want to. So I think that's something that it's good to know and keep in mind. But yeah, I think we have to move on because we don't have. I mean, and also I want to say that I will not be able to tell you everything about IPRs and licensing in just 1 hour, but I hope that this will get you started and you will learn where to find out more information if you are interested in these topics. Alright, and then, okay, we covered company names, yes. So let's go forward. So trademarks, I'm sorry there's a lot of text, but I think you will get this slide.
Yes.
So I will not read everything, but it's for you to have the presentation, so you can afterwards dig into these topics. So trademarks are regulated by the Finnish Trademarks Act, and as I said, it is a distinctive sign that distinguishes companies' goods and services from other companies' similar goods and services. So trademark gives an exclusive right to prohibit others from using a similar or same sign for similar goods or services. And so it is a distinctive symbol on the market. So basically anyone can apply for a trademark, individuals or businesses or entrepreneurs, they are mainly intended to be used in business, but there is no restrictions for, like, anyone can apply for a trademark. And so the prohibition right gives you an effective way to protect your brand. We heard about branding on the previous session, so it's good to also know the difference between a trademark and a brand, because a brand is more of the images associated with the company or the goods or services. Trademarks are, of course, strongly linked to brands, but I think brand is a broader concept, and the brand, like, itself cannot be protected, but all the visual elements in a brand can, of course, be protected. For example, the logo can be protected as a trademark, also the slogan or any design related to the branding. But yeah, so the format of the trademark can be of any kind as long as the representation is clear and precise, and this means that you have to be able to present it in the register. So if you have a nice logo or whatever, then in order to apply for a trademark, you have to be able to present it clearly. This means that you can even have, for example, sound marks. I think Netflix has registered when you open Netflix, there comes the music and the visual elements. So that can also be registered as a trademark, as long as the representation is clear and precise. So you can, for example, register a smell, because you can present it in the register. But most common trademarks are word marks, such as Nokia, simply, and figurative marks, such as the Terveystalo here, which has both the word and also some visual elements. So also the exclusive right for a trademark only covers the specific goods and services listed in the registration. So if you apply for a trademark, you have to choose what services or what products you are going to offer under that trademark. You cannot, like, if you have a trademark, it doesn't cover all the services and products in the world. So you have to define the scope of protection. And with trademarks, we have this classification system. So you have to choose from classes 1 to 45. This is a bit technical information. But if you are interested in applying for a trademark, the PRH, Finnish Patent and Registration Office, has very clear and easy to understand websites, also in English. And you can always, if you want, you can call them. They are very helpful if you have a specific question. Of course, I can also advertise legal advice. If you are ever uncertain, it is always good to contact a legal professional to ask for help. And also, the right to a trademark is only valid within a specific area. If you apply it here in PRH, it's only valid in Finland. There is also EU trademarks, which cover all EU countries with just one application. Yes?
Just talking about EU, does the European law regarding copyright takes precedence over Finnish law?
Well, Finnish legislation is largely harmonized with EU law. So, for example, the Finnish Trademark Act is based on European law. So yes, they are harmonized.
And actually, a question about this legal support. Out of curiosity, are you personally, for example, ever involved in helping, let's say, trade unions, or so? Are you providing your legal help ever through some bigger association or union or something like that? Do you?
Well, no, not at my workplace. We mainly work with business clients straight.
in this context, I think that first of all, I agree with that seek support. We have talked a lot about networking here, and that it
Yes.
might be worthwhile, especially in the arts and well-being sector, to build alliances, seek support, not trying to do everything by oneself
Yes.
regarding branding, legal issues, etc. But it might not be realistic for all these micro entrepreneurs to have their own private legal support, but then you should maybe belong to some bigger union or something like that, and there you can get.
Yes.
I don't know how good, for example, I think that they might be, at least in the arts unions, quite good in this.
Yes, I think so too. Yeah. Yeah. So that's a very good point, Ville. And yeah, so I will try to be more quick. A trademark registration is also valid for 10 years at a time. It can be renewed for unlimited periods. So a trademark can be enforced forever if you just renew it every 10 years. And then here is some practical tips regarding the registration and use. It is always good, before you apply for a trademark, you have to check whether there already exists a similar one. If you apply in Finland, you have to check whether there are Finnish trademarks, but also I mentioned the EU trademark, which covers all EU countries, including Finland, so you have to also check EU trademarks. And here are, I have added links to the databases, so you can do yourself a quick search. These are quite easy to use databases, so you just either type in the name you want to register, or you can also add images in the search, and then you can see whether there already are similar ones existing in the similar products or services, so you can get a better understanding whether it would be possible for you to register your mark. And also, I mentioned the classification system, so I recommend that you choose the goods and or services you intend to use for the trademark very carefully, because after you have registered a trademark, you cannot add any additional products or services to the protection. You always have to apply for a new mark if you want to, like, you want to offer, for example, yoga services under your mark, but you haven't registered your mark to any sports services. Then you have to apply for a new mark and do the whole process again. And also it's good to use the mark consistently in its registered form. For example, use in all capital letters. Don't inflect the trademark, so it's like you separate it from other marketing. And also the symbols. Well, you see a lot of these symbols being used. The R means that the mark is registered, and the TM indicates that the company is using the mark as their trademark, but they haven't registered it. But they are indicating to others, like, hey, this is my trademark, don't infringe it.
Sorry.
Yes.
Is there any some kind of statistics of, like, for every company that there is, how many actually have a registered trademark?
Sorry, I didn't hear you.
Like, is there a statistic of, for as many companies there are, actually only a percentage of them actually have a registered trademark? Like, is it 1 out of 10, 1 out of 100 companies? What might that be?
Unfortunately,
Like, thinking
I
about the
don't.
value of a registered trademark,
Mhm.
also considering that how much it costs to have it registered and that process. But what is that real, like, threshold and point of?
Yeah, well, I would say that all the large companies have registered at least one mark. And, well, regarding the costs, applying for a mark in Finland is not that costly. It's under 1,000 euros in total. It depends on how many of these goods and services you choose to protect the trademark. But I'm not aware of any statistics that much. I think it's like smaller entrepreneurs who don't really, they don't maybe know about the application process, and they think that, well, this is not that important, or my business is not large enough that I should apply for a trademark. And then afterwards, that they have been in the business for like 5 years. Well, my brother is a good example. He has this ice cream business for I think 6 years. And just last week, he was like, "Hey, I could now apply for the trademark. Can you help me?" And I have been telling him since the beginning of this business that you should apply for a mark. You have a nice logo, nice color in it, and a slogan and everything. And he's like, well, it's not important. But if, for example, if he wants to think of selling his business to another, it's a very good asset to have a trademark protected. So.
And exactly as you said, that small businesses don't necessarily do this, but it's, I would say, important or a good thing to at least consider for two reasons. Firstly, as a thought process, even if you don't then apply, but if you even think of this and then you try to, develop your, not just the appearance and brand, but also in a deeper level what you do in such a way that you could then register it. It probably helps you develop your offering. That's for one.
Mm-hmm.
And then secondly, there are many cases, even in really small business markets, where there have been quite kind of tedious fights over certain brands, trademarks, where two competing actors both claim that they own certain brand, and then even if you eventually win that case, you know that you can, because of course even if you haven't registered it, isn't it so that if you can prove that you have actually used it, then you can claim it for you.
Yes.
But still, you need to consider that, do you want to enter into those kind of fights and spend a lot of your resources? Your life is so much easier if you have the registered trademark in the first place.
Yes. Yeah, with trademarks, it is also possible to acquire like the status of a registered mark by establishing your mark if you have used it many years consistently. But I always recommend to just register your mark. It's so much easier to prove that you have the right to the certain mark or logo or word, whatever, than showing that you have actually established the right by using it many years.
Within the application, can you have sort of variations of what that logo looks like? Or is it like fixed?
Well, yeah, in the application you must present just one version of the logo. Like, of course, you can use your logo in whatever shape or color you want, but you can only apply for the trademark in one certain visual appearance. Many larger companies apply for the same trademark in different colors. For example, if they use their trademark or the figurative mark in many colors, they apply for all the colors. But as for smaller entrepreneurs, it's basically more cost efficient and more easier to just apply for the one mark in the format that you generally use it. Yeah. But in the application, you cannot present like alterations. It's just the one logo in
And
one
if you do like a
application.
rebranding thing and 5 years later you decide to make a bit of a change, but you only do it every 10 years, should you then immediately update and pay that €1,000 to, or do you get a discount because it's 5 years before?
I mean, many companies do that such a rebranding regularly. So then we always advise them to apply for a new mark for the new logo if they do a rebranding thing. Alright. I think I have to skip something because I only have 25 minutes left and we are in the company name section, but let's go quickly. So yeah, company name is the name used to identify a company, and if you want to have an exclusive right to a company name, you apply it from the Finnish Trade Register, which is individual and distinctive, meaning that their company name cannot just simply describe the type of business you are offering. Like it cannot be just art Ltd. And it must not be confusable with another's protected company name, secondary symbol or trademark. So as with trademarks, company names cannot be confusingly similar with someone else's earlier company name or trademark. So that's why on this next slide I have added the same suggestion to check before applying for a company name whether there already exists similar companies in the similar field or trademarks that are registered in the similar. Yes?
Small technicality about the registry. I mean, I have a domain name already, but
Yeah.
in that name registry, could you add? Of course, you don't want to be misleading, but it doesn't really. Unless I'm thinking, like, could you have a name of something and then add OY just because you like the name of the letters OY? Or would that be like, no, you cannot do that because companies technically there's OU,
Yeah.
which would then be like you're trying to say that your company is OU, but really it's just a domain name.
Yeah, I
Is there
think
anything about saying people like?
I think that would not be accepted. Like that would be maybe confusing.
No, but I'm just saying like, oh, I like the letters OY because in English it's OY.
Yeah, I know.
But then you're
But
like,
if you
but this
apply in Finland, I think
Yeah.
the PRH will assess in the Finnish language. So,
is, yeah,
yeah. All right. And then, yeah. And then, of course, with family names, maybe many of you already have like a toiminimi, single entrepreneur. Then you can use your own name, but as long as it doesn't cause confusion with another one's company name or trademark. But you can always add a distinctive element to it, and then it's
Just random, how easy is it to change your name once you have a toiminimi?
I think it's quite easy. I think in PRH's webpage they have this alternative to make changes to your name. However, because you cannot transfer your company name, if you want to transfer it, you have to first end the whole business, and then someone else can start it over with the same name. But then first it has to be deleted from the trade register. But I think you can do some alterations to the name.
No, change it completely
Okay.
to something
Well,
else.
I think then you have to first delete it and then do another application.
Okay.
Yeah. But PRH has good web pages, and as I said, you can also call them and ask. Yep.
I did change my toiminimi name completely to something very different and people like toiminimis.
Okay, so it's possible.
Yes, I
Good.
just wanted to say this. If you go to the website, you choose your name and you have an option to add another name. You have a transition of 2 days where you're going to have 2 names showing up
Yeah.
after you receive the letter saying that your name has changed.
Okay.
So there's no pain.
I don't think so, no. But you have to have, just to change that toiminimi name with the same address and everything.
Yeah,
I did this in 21, so I don't know if the law changed since.
No, I don't think it has changed in that sense. So yeah, there is possibility to make alterations. That's good.
Thank you.
Yeah.
You're welcome.
So I think we can go forward. Okay, copyright. Let's check some details about copyright. And so copyright protects the independent and original expression of a creative work. So please note that it only covers the form of expression, not its subject matter. So it doesn't cover ideas solely or any information contained in the work. And this is important to realize that only when you have an idea and you put it in your artwork, then the artwork, if it's original and independent then it becomes copyrighted. But just the sole idea is not protected. And this, I added because I found out an interesting statement from the Finnish Copyright Council from last year. And this case was about the copyright of an art project against school bullying. There was this applicant who said that another organization had copied the project concept basically, but the other party said that no, concepts cannot have copyright protection, and then the council said that yes, so the copyright protection doesn't extend to the idea, methods, or an artistic concept of the work, and in this case the council said that only the project's activity description and action plans were protected by copyright, because then the idea was like put in paper. So that's good to realize. And so with copyright, the author must always be a natural person. So it requires human effort. Nowadays, many people are using artificial intelligence when using or creating art or whatever. And yeah, you can of course use AI to create outputs, and they could be seen as copyrighted works themselves. But despite of this, these kinds of works of art have not yet been granted copyright. It's good to realize that if you use AI just to assist in creating artwork, then it doesn't directly preclude the possibility of obtaining copyright, because it's always the overall assessment of to what extent the author has put his or her input in it. Yeah.
Do you know if there is any moving forward towards this interaction between artist work and artificial intelligence? Because at least there has been a big discussion on social media of artificial intelligence taking original works and using them to update their, databases and create artificial intelligence images. But do you know if there's any moving forward? Have you heard of anything that will protect the artist on a legal way, if there has been like artificially created copies of their work?
Well, yeah, I mean, this subject is very much everywhere nowadays. But the main, what I have heard, and please know that I have been at home for 1 year, and I am not probably that updated on the latest developments. But yeah, if you create something with AI, even though you feed the outputs to the AI, I think that not until today those kinds of arts have been granted copyright protection. So, but this is always a case-by-case assessment. You cannot say for sure this gets protection and this does not. It's case-by-case basis assessment. And yeah.
You said there was a certain measurement, that there was a certain percentage of the art is AI or something like that?
That could be one assessment.
How do you measure that percentage?
Yeah, that's a good question. But of course, ultimately, the courts make the decision on whether a product or a work of art gets copyright protection, even if you have used AI in it. So I don't think there is any percentages. It's just the overall assessment. Yes.
Yeah, I need to do a remark again. So this tells again how important it is for you to properly brand your offering, because as it says here, if you for example go to the healthcare sector and go there for example with your artistic method to help the patients, someone else can participate those sessions, copy the whole method and start selling the same thing, and it's quite hard for you to kind of protect that alone. But if you have branded it, you have given it a name, you conceptualize it, you gain reputation, then even in that case that somebody starts copying, you are on a much safer ground because it's your branded like name X that the customers distinguish that okay, this was the original one, this is the method, this is the Burana of Arts and Wellbeing type of thing.
And of course we have law regarding unfair business practices, which basically like fills in the gaps in between intellectual property rights. So even though you couldn't get, let's say, copyright protection, or you haven't registered your trademark, but still someone clearly infringes your rights, then there is this Unfair Business Practices Act, which could be used to solve the dispute. Yes?
I'm sorry to interrupt you. I just wanted to add this about AI. If you create a work with AI and somebody else takes it, a judge recently stated that prompt history is proof of work. Like if you show up to court and you say, this is my artwork that I created by AI, and you show up 500 prompts to ChatGPT, for example, that proves that you did it. If you're facing somebody who just shows up and said, this is mine, and he cannot show the prompt history. So that's all I wanted to say, because there is a lot of things at the moment say, what if I create something, somebody just steal it? You can always have a ledger and show what you've done before, and then that's proof of your work.
Yes. Yeah.
But that's common law, because the judge was in New York.
Yeah.
I don't know about civil law in Finland.
Yeah. It's good to realize that U.S. law, which is a common law system, is very different from Finnish and European copyright law, for example. So yeah, there might be some judgments very different than we have here. Okay, but let's go forward. So if your work received copyright protection, it's valid for the duration of the author's life, plus 70 years after the author's death in Finland. And yeah, so no registration is needed, and you, as the copyright holder, receive a lot of different rights. There are economic rights, which means that you have the power to decide whether your work is used or not used, and then moral rights are rights that protect the person and the integrity of the author. So e.g., for example, you will have the right to claim authorship, meaning that your name as the author must always be mentioned if your work is displayed publicly. And sorry, I will go a bit quickly. So, okay, so we already covered these requirements a bit. So, in order to become protected, the work must cross this so-called threshold of originality. So it must be an intellectual and creative effort on the part of the author. So nothing like the quality of the work doesn't matter in the assessment, or how many hours you have put in the work, it doesn't matter. And ultimately, the level of copyright is assessed and determined by the courts on a case-by-case basis. Then we have this called related rights. I will not go any deeper into these ones, but it's good for you to know that there are, besides copyright, we have related rights which resemble copyright but are a bit narrower in the protection. For example, if you take a photograph, which is like very common and does not cross the threshold of originality, it will be protected by a related right. So, but the main difference between a related right and copyright is the period of protection. So usually related rights are valid for 50 years, whereas copyright was protected for 70 years plus the author's lifetime. Okay, and then, yeah, just an example of different works that can be copyrighted. nice overview of what different IPRs can this kind of company have. I checked just quickly, they have at least 2 Finnish trademarks, these sort of figurative marks. Then, of course, they have the company name, copyright and related rights. Since they are not registrable rights, I just mapped out here myself what kinds of works could be protected. So, of course, any performances they do and any works of art related there, such as maybe the clothing if it's original and independent enough. The logo, as well as it's a trademark, it could also be protected as a copyright. Then original photographs that they take, website graphics and content can also be, if it's crossing the threshold of originality. Yep.
How would it work in some way regarding, because I can understand with the domain name, that directly points to the organization. But
Yeah.
for example, like I use Wix website, but then my domain is a subdomain of Wix, yet my photos and things and text are all there. So technically, who is it? Is it within that agreement that I signed? Of course, there's that spine text, but I probably haven't read it properly because I'm like, I just want to put my stuff there.
Well, with domain names, I added here, but domain name is not an IP right as such. So it's different than trademarks, for example, or copyright, because they are not like this form of creativity, or they don't represent creativity as such. But yeah, from a business perspective, they are important because they represent the online brand or the online identity. But yeah, if you have registered the domain yourself, your own, even though it's made on, even though your website is made on like these website providers, then like you own the content of your website. It doesn't matter if you build it. Of course, you have to be sure about the terms of use.
Well, that's thing. Yeah.
And that's, we will soon go to licensing. So terms of use are also sort of licenses. So like how you can use their, the platform or whatever. But yeah, just keep in mind that domain names are not IP rights as such. But they are usually very important for companies at any size. Yeah, but okay, so hopefully you will get a better understanding of what kinds of IP rights a company in this field can have. And then, yeah, we have also restrictions to copyright protection, so it's not like absolute. If you get a copyright protection, we have limitations. And the limitations are due to societal interests and freedom of speech. So these 4 ones are probably the most used limitations. And so these are not all limitations that the Copyright Act has. Keep that in mind. But yeah, we have the private use. So even though someone has a copyrighted work, you can, as a private person, not companies, to make a few copies for personal use of the work without asking for consent or permission beforehand. Then you have the quoting rights, so you can quote someone else's text. Image quote is, well, the right to quote also includes images because it doesn't, it's not connected to any type of work. You can quote whatever works if you do it according to the law. But the Copyright Act also includes image quote regulations. So, for example, in a news reporting, you can include an image of art in a news reporting or a scientific presentation. Then we have the parody, caricature, and pastiche limitation. So you don't have to ask for permission from the artist if you want to use a published work in a parody, for example. And internet memes, for example, go into this category. That's why everyone can do a meme without asking for the consent from the original author. Did this answer your
Well,
question?
yeah, because I found a piece of art from a very good artist, and I modified it in such a way that it was sort of making it a more like political or satire type thing. So I just shared it online on like Facebook, but I haven't like
Asked for a consent or?
yeah. So I mean, like it was kind of like what came to mind is imagine Da Vinci was alive and he's like, okay, I want to make a Mona Lisa. And then it's there, now it's his thing, but now he decides to post it online and somebody kind of modifies the face to be like a face of a dog or something. Then like what right does Da Vinci have?
Well, of course, first you need to check whether a copyright is even valid anymore, because it's not valid forever. With regard to old paintings, for example, they usually, the copyright has expired. Then you can do whatever you want with it.
But if it hasn't expired, it's like an artist that I found was Michael something. There was a few years back when actually Trump was president.
Okay.
And what was happening at that time. So
Yeah.
it actually is odd how it has come full circle again. It seems relevant and I want to share it.
Yeah.
But like, would it be questioned?
Well, I would be quite careful with these kinds of alterations, because copyright, it gives to the author also the right to decide whether the work is altered. So, but if it falls into this parody or caricature limitation, then it's fine without asking a consent.
Should I even just write for artists and say, hey, do you mind if I share this?
Why not?
Yeah.
Yeah. Okay, so I already mentioned that you can of course freely use works that are no longer protected and materials that are not protected in the first place, meaning that a piece of art doesn't cross the threshold of originality. You can utilize ideas of another person's works in your own production if you want to use it to create your own independent and original work. And this is called a free adaptation. But please keep in mind that, for example, if you want to create a painting from a photograph, this usually requires permission from the copyright holder of the photo. Because, as I said, copyright provides the author with the exclusive right to decide whether the work is used in its original form or in an altered form. But whether it's like with free adaptations, it's again the question of case-by-case assessment. So, and differentiate the free adaptation from composite works, which means that you are combining works of art yourself by creating a new one. So then you require permission from all the artists, all the authors that you want to use in your work. Okay, can we just go quickly through the licensing basics?
What's the agenda say?
We have to make a negotiation then with the audience because we have a very tight program. So we have an artist invitee after this. If you are willing to stay a little bit longer than 16, then she can continue with the licensing part for a little while. If not, then
Can we shorten
yeah,
section?
as well. Yeah.
I think this licensing is, because it's for
Yeah.
the arts and well-being
Yes.
topic, is really relevant. I would
Yeah.
go through it and start the break a bit later.
So, okay, licensing. So, you can only license IP rights that you own. That is why this is the first slide. So you need to realize who owns the IP rights. We have gone through these, basically, copyright. The creator of the original work is the owner. The trademarks is the individual or entity that uses the mark and has registered it. Patents, they are usually the inventors. And of course, in employment agreements, you can agree that the employer owns the rights. But let's see what licensing actually means. A license means a right to use, and licensing your IP means that you grant rights to use your IP to another legal person, and this is done through licensing agreements, basically. Licensing agreements are commercial agreements, which usually require some legal help to draft, but we will go through quickly the typical structure of the agreement. But just to familiarize yourself with the concept of licensing. So if you license, meaning if you give a right to use your IP to another one through a license agreement, you still keep your rights to the IP. The ownership doesn't change. And you remain responsible for example, for the maintenance of the trademark, like you have to still remember to renew it regularly. And the licensing agreement can be exclusive, meaning that you only give the right to use to one entity, or it can be non-exclusive, meaning that you give the right to use the same IP to multiple entities. And yeah, well, selling your IP is, on the other hand, that you transfer the ownership of your IP to another one. And then the buyer gains the full control and ownership of the IPRs. So it's good to know the difference between licensing and selling. And these are the types of licenses that are the most common ones. So you can license your trademark. You can add copyrighted material to the right to use. Then it's usually called a brand license. There is of course copyright license, which can also include trademarks. And also terms of use of services are licenses. So if you, for example, subscribe to Spotify, you accept their terms of use before. And that is a sort of a license agreement that you enter with Spotify. And I don't know if you have heard about Creative Commons, but these are kind of open licenses that artists can and authors may allow to use their work under certain conditions quite freely. You can you know when for example a photo is under a Creative Commons license, it has the CC mark on it, and there is the link to this search page, which is quite useful. And so why are licenses granted in the first place? Well, usually and ideally it benefits both parties. So licensing allows the licensor to generate revenue and grow the business. For example, if you license your art to a manufacturer, meaning that you give a permission for the manufacturer to use your art, for example, in, let's say, clothing, t-shirts, whatever, in exchange for payment, then every time the manufacturer sells this kind of t-shirt with your art on it, you earn money. Usually through royalties, which are like percentages of the sale. And of course, it can be an easy way to enter into markets, as the licensor does doesn't need to acquire any sales or marketing channels or the associated costs. You will save money. And then, like, you don't have to use your own resources to produce the product if you have just a good artwork that you can sell, not sell, but give a license to a manufacturer that they can use your art in their production. And you can, with licensing, you can expand your business into new products or services, or even try markets abroad. Well, there is Angry Birds is a very good example. They have licensed their brand to nearly everything from clothing to fishing equipment, I think. And then licensee, who has the right to use, benefits by having access to there is a typo, I think, but they benefit from the license by having access to an already developed art or design or trademark. That should be really there. Yeah, so these are like the main reasons why licenses are granted. And well, I don't think you are that interested in hearing about this legal stuff, but this, as I said, licensing is typically done through a license agreement, which is a commercial agreement, and it's subject to freedom of contract, meaning that the parties can generally agree on the terms as they wish. But this is a typical structure. I will not go into deeper level here since we are already over time, but just to get an overview of the terms, what are typically included in the license agreement. Here's another page. Let's see. Maybe from the license agreement structure, it's good to point out to be very precise with the subject of the license and the license grant. So if you don't remember anything else from this, please remember the second and the third box. These are maybe the most important ones. So who are you giving the permission to use? On what products? How long? On what geographical areas? Yeah, so some practical tips. I always recommend to put the agreement in writing. Of course, there is nothing to prevent you from doing contracts just like without writing anything down, but it's always easier and more efficient to show what you have agreed if you have put it down. And let's see what else I have here. Yeah, well, I already said that be very precise and clear with the definition of the scope of the license. And also, if you want to license the same artwork to many companies in order to maximize your income, don't give an exclusive license to anyone, because then that means that you cannot give any other companies the same license, and you are stuck with one entity. Of course, with licensing, there are possible risks. For example, quality issues may arise, that the product where your artwork is used is not the promised quality, that can result in reputational damage, or the licensee doesn't pay you the agreed license fees. But with commercial agreements and licensing agreements, there are also these kinds of risks that has to be taken into account. Alright. Yeah. Well, I think that was the licensing part, and if you wanted to end my session, I only have these data protection points left. But no, I mean, we can skip this part if you think we are already over time.
I told our next
we have freedom of enterprise as a basic principle in Finland. So in general, if we think of an artist entrepreneur operating in the health and well-being sector, it doesn't really require any specific permits or licenses from the authorities. Usually if you operate yourself a private healthcare service, for example, then you have to apply for a specific permit to do so. And also generally I don't think that there is any requirements for professional qualifications in this business. Regulated professions include healthcare professions, social welfare professions, and then you need to apply from relevant authorities for the recognition. But of course, if you would offer your art to a hospital or similar, then the artwork must usually comply with their own quality and hygiene requirements. But these are agreed with the hospital or similar facility in question. Yes?
Therapeutic activities. What is that as defined?
Well, that means more like psychotherapy, such as you have to study yourself, the profession. But I mean, therapeutic activities such as, well, I don't know if yoga is such or
Yeah, if they are regulated, so in Finland you can actually call anything a therapy, but then there are also certain like psychotherapy.
Yeah.
If you can't call yourself a psychotherapist
No.
if you are not a licensed trained psychotherapist,
Yes.
but you can call yourself a therapist of any sort if it's not in the field of is protected.
yeah, that's correct.
And maybe one kind of just encouraging advice on this, if you consider entering the healthcare sector as an artist or culture professional, don't hesitate what comes to licensing. So it's then the healthcare organization's duty to ensure that you comply with their requirements, but you don't need to know too much beforehand about this art healthcare specific
Yeah.
requirements.
Yeah, good point. And there is this suomi.fi webpage which has very clear information about whether, like, which operations require a specific permit or license. There is even this kind of questionnaire that you can just fill in, and it tells you whether this kind of business needs any professional qualifications or other permits. So I would check their webpage if you want to know more. It's also in English. But of course, you must always submit a notification about starting a business at the Finnish Business Information System. But this is probably information that you already know, that you need to inform at uti.fi if you want to start a business. Okay. Well, are we out of time? I'm sorry. There were so many questions,
Thank you
which is
very
very
much.
good. I'm happy that you had questions. But
Thank you very much.
yeah.
Leila.
Thank you.
I already started liking these microphones, but I couldn't get it on.
Yeah.
Are we still having a 10-minute break?
Yes, we are having.
Which means that we are getting refreshments here now and continuing 25 past. And because this is the last break before we are wrapping everything up and going home, I'd like you to remind that now is the last time for you to ask that question from that one person you're thinking that should I go to that person and tell something or should I not? And also, if you don't want to stay here after school, you need to reply to the questionnaire of the feedback. We'll put the QR code here also.
Could you put the feedback form?
Earlier today.
Teaching dancing?
Well, not at the moment. Yes. No. But I've been in the field. I have a background in dance. And then, many things for that. Yeah. Well, now, since I'm back in Finland, I was